case number 110977, Jamerson versus Heimgartner.
If it please the court, I'm Nancy Ogle here on behalf of appellant James Lee Jamerson. I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
As the court, I'm sure, is well aware, we're here on this case. The court granted a petition for review and limited the issue to be addressed in this appeal to whether the duration in administrative segregation alone implicates due process liberty interests. And the standard of review this started out is a habeas corpus case that was filed in district court, then taken up with the Court of Appeals, and now we're here. And in the district court, the habeas corpus petition was summarily dismissed, which means the standard of review is unlimited, as well as the fact that the issue presented is one of law, so again, an unlimited review. The court, in its review, as far as facts, unlike some cases that you hear, in a habeas corpus case, the facts as set out by Mr. Jamerson have to be accepted as true.
And what do we know about the facts?
Well,
and I understand his complaint basically is that he was placed unjustly or incorrectly in administrative segregation. That's the gist of his complaint, at least initially. And it's expanded a little bit, but he doesn't really ever articulate what the conditions of his administrative segregations were. And do we know? We have an amicus brief, we have your brief, but that describes some of the conditions, but it doesn't. He never really states it, but it's never really been found on the record anywhere. Do we know what specific conditions he was continually exposed to for appears to be a 5-year period?
I think, you're correct that he doesn't articulate those conditions. I think he's relying on the fact that the length of the time, and that he should, and his argument is that he should not have been there in the first place.
But the issue we want to address is whether duration alone can
Right.
make out a due process claim, right?
Yes, right.
Or a deprivation of liberty interest. So I think my colleague's question is, do we know what the conditions are in administrative seg? And I would just add to that, do we know how, if at all, they differ from disciplinary seg?
My opposing counsel can probably answer that more thoroughly. One of the reasons...
But will his answer be based on the record in front of us, or will it be based on some personal knowledge of his? Do you know?
Well, I think his answer will be based on what the rules, regulations within the correctional facility are, and he has more experience actually seeing that in action than I do. But that is also why in my brief I provided a short discussion of disciplinary segregation versus administrative segregation, because that was obviously a distinction in this case, which was a new area for me to learn about, and I wanted to share that knowledge if you didn't already have it. One difference about disciplinary segregation is there's a limit of 45 days or 30 days, depending on the class of the offense. For disciplinary segregation. So that is one difference. But as far as, 3 showers a day, 5
showers
hours
a
of
week.
exercise a week, I think those are the same. And Mr. Smith can correct me if I'm wrong.
And should the comparison be made to what Justice Beyer referred to? Should the comparison be made with conditions that are similar or different from those in disciplinary administration as opposed to administrative segregation, or should it be conditions that other inmates are exposed to in the general population? How should the comparison be made in determining whether conditions are extreme or unduly harsh?
Well, the question as far as establishing a due process liberty interest, I think based on past habeas corpus cases in this state and probably elsewhere, is whether Mr. Jamerson can show a significant and atypical hardship compared to the normal incidence of being in prison. Obviously, he's not going to be compared to anyone outside prison. But I think the comparison, if I'm understanding your question, is not so much the comparison between disciplinary segregation and administrative segregation, but the general population and administrative segregation.
And do we have anything in the record that compares administrative segregation from the general population?
I don't know that we have anything in the record of, say, daily life in general population versus the segregation, administrative segregation. But, I mean,
My problem is I'm having a little trouble divorcing conditions of confinement from duration. Obviously, he's going to have a long duration because he's incarcerated. It only becomes a process issue if, as you mentioned, those are atypical hardship from somebody that's in prison.
Right.
And if we don't know what the conditions under which he's labeled administrative segregation, then how can we make this determination based simply on number of days, 1,000 days or whatever? I mean, I don't see how you can divorce the conditions from the duration.
Is segregation enough?
well,
Especially when you add it to durations. Segregation for 1,000 days as opposed to 30.
Well, I think the condition, I see what your problem is, or question, is the comparing to the general population, and I apologize for not including that in my brief, but those things are set forth in regulations and IMPPs that are legal, they aren't facts that are specific to Mr. Jamerson, but they are the the conditions that are established by the correctional facility.
You're suggesting that we can take judicial notice of the IMPPs?
Right.
Okay.
As far as, granted, the record is very small in this case, as it typically is in an appeal of a habeas corpus under 1501. But Mr. Jamerson has alleged, which you have to treat as correct, that while in this 3 to 5 year period of administrative segregation, he developed depression, anxiety, panic attacks, several different symptoms of mental illness. And I realize it's not in the record. He has personally written to me and given me a list of his medications, and there's like 10 of them that he takes. And as the amicus brief particularly points out, that these long durations in segregation, often lead to mental illness. And so essentially we're arguing that that's atypical and significant if someone walks in without any mental illnesses and then, is then confined in segregation for so long that they develop multiple mental illness disorders.
If your client is no longer in administrative segregation in that custodial environment, what remedy does he seek from us? Or do you seek?
Well, even if he is no longer in administrative segregation, it's obvious, well, I shouldn't say it's obvious. I am asserting that this happens fairly regularly. I think opposing counsel even mentions in his response brief, that there's at least one inmate at El Dorado who has been in administrative segregation for 20 years. Well, so it's not just happening with my client. And if it's consistently resulting in a significant number of inmates having mental disorders as a result, then I would argue that this isn't moot whether he's in or out of segregation at this point, because it's likely to recur and actually is happening.
This is an action brought by Mr. Jamerson for his conditions, not for
Right.
other inmates. And I appreciate, so we should issue a decision that does what? That sets out parameters of how just where are we going with this in terms of this particular case? And are you seeking to expand the base, your client base? I'm just not clear. No. What are you seeking?
Well, I would like this court to find that duration alone can implicate a due process liberty interest. And since he was never given any kind of hearing at the district court, because that would be a change in the law, that decision be made. Now, whether it has an impact on Mr. Jamerson being able to go back and having a hearing before the district court, I would think he still can do that, whether he's in or out of segregation.
Counsel, would it be a change or a distinction? Because our
Well-
previous Kansas law deals with placement in administrative segregation, doesn't it? Or placement in disciplinary segregation.
Right.
We don't have a Kansas case on duration, do we?
Not that I'm aware of.
Okay.
Counsel, what is your what is your best authority? If we don't have decisions in Kansas on this issue, where would you point us for the best case that points us to the holding you're asking us to make, which is that we can, that duration alone can implicate a liberty interest?
I'm apologize for not knowing the name of the case immediately, but the Sandin, which has been cited by this court, but the U.S. Supreme Court, and this summer they issued another, I'll have the Davis versus,
That's the Ayala
Yeah.
case.
and I quoted not the majority opinion, but a concurring decision by Judge Kennedy.
So is Justice Kennedy's concurrence in Ayala kind of the best authority for this proposition?
I think so.
There was some mention in the record about that even though your client had been removed from administrative segregation, there was still kind of like almost a parole type of situation was maybe an analogy that you could draw to it. I mean, it wasn't really described, but it sounded like there were still some restraints on him or additional requirements that he was having to meet than the general population. Do you know anything about that, or is that in the record at all?
Well, it's not thoroughly developed in the record, and again, opposing counsel may be able to address it more clearly, but as I understand it, it's basically when you're in administrative segregation, there's in order to make a transition back into general population, the inmates are required to go through basically like a behavior modification program, and they have various steps to go through. And one of the last steps is that they are returned to general population, but then if things don't go well, they haven't, the restrictions or the threat or process of going back to general administrative segregation kind of hangs over them, and if there's a misstep, then they go back.
I have a
and
question that
regress
arises out of that.
in the behavior modification program.
What's the point of the behavior modification? Is somehow to make a transition from being segregated to being back in population? Because it's not necessarily the conduct of the inmate that places them, that necessitates administrative segregation in the first place. Sometimes it's the conduct of their fellow inmates and
Right.
the need for additional safety for the inmate who's placed in segregation. So in this case in particular, do you know why behavior modification was required?
Well, I think it was
A behavior modification course or training of some sort?
for Mr. Jamerson, I think it's twofold. One, the inappropriate classification of him being a gang member, which was dispelled 3 years after he went to segregation. And then also, he defended himself. Those are set out in the facts in a fellow inmate when he was at Lansing was making threats, and they finally got into a fight, and Mr. Jamerson defended himself. And to my understanding, there wasn't a disciplinary report written up as to the altercation between Mr. Jamerson and the other inmate. They told him it was because they relayed him to gang activity, which was not true.
Any further presentation? Counsel, you have any further presentation?
No, thank you.
Any more questions? Thank you, counsel. Counsel, before you begin your arguments, I wanted to acknowledge a group of people just came in. Could someone please identify what the group is, please?
Hello, Your Honors. We're a government class from Topeka High School. It's a pleasure, privilege to be here and observe.
Very good. Welcome. Thank you for coming. You may proceed.
Good morning. My name is Michael Smith. I am the counsel for James Heimgartner, the warden of the El Dorado Correctional Facility. I think you have a lot of questions, and so I'll be brief in my presentation. Mr. Jamerson was, just to review the facts very, very briefly, was an inmate at Lansing Correctional Facility. He did get into an altercation when he had a homemade weapon. He stabbed another inmate. He did go through a disciplinary proceeding. He was placed in disciplinary segregation for 60 days and ultimately transferred to the El Dorado Correctional Facility, in which he was classified as an other security risk. He was required, after evaluation, to take the BMP, Behavior Modification Program, which he was enrolled in, since he has since completed that program and returned to general population. This case arose during that period that he was still in administrative segregation.
Counsel, if we look at the administrative regulations and the, I can't remember what you call them, the internal rules of operation.
IMPPs.
Yeah. If we look at those two sources, can we identify the path that Mr. Jamerson took through all these proceedings that you've just told us about? In other words, the disciplinary segregation, the transfer, the reviews of all these things. I mean, is that going to lay out, sort of like if we look at the two sources together, will that show us, basically sort of a code of criminal procedure or civil procedure might in litigation, so that we can take judicial notice of what's going on?
I believe so. I think there are a couple of IMPPs. There are several that deal directly with segregation, both disciplinary and administrative segregation. In another section, there's an IMPP that deals with, I will just go ahead and refer to it, or I didn't bring it up, that deals with programs that are conducted when an offender has been placed in administrative segregation. There's not just BMP, there are other options that are there.
Would you tell us what that is? Did you say DNP?
Oh, a BMP, Behavior Modification Program.
That's the program that he needed to complete before he could be returned to Gen Pop?
Yes,
Okay,
yes.
Thank
And that there's an IMPP that addresses those programs that assist offenders, because Mr. Jamerson wasn't placed in administrative segregation because he, of any other reason than the fact that he tried to solve a problem with violence. That's just not acceptable in the correctional
But he
environment.
served a disciplinary segregation for that fight, didn't he?
Yes,
You said he served 60 days for that,
yes,
and then he was transferred.
yes,
And when transferred, he was classified as, quote, other security risk.
correct.
What does it take to be classified other security risk in the prison system?
It takes the evaluation. It can be any number of things. There are probably, if you look at the IPP, 15 different
So
classifications.
which reasons applied to him other than the fact he'd been in a fight at the previous
The
institution?
use of a weapon, violence generally will do it, escape.
I thought in this case it was because he had an association with gang members. At least,
That
if
was-
we take the face of his complaint, that's what he says.
Yeah,
And that was 3.5 years later, that was shown to be not right.
correct. That,
Isn't that correct?
that is correct.
So 3.5 years, he's placed in segregation on something that he's been complaining about from the very outset of his placement there. The very outset, he wanted a review as to why he was put there. Many of those went ignored, and it wasn't until 3.5 years later that it's determined, oh, that was a mistake. and then it's another year and a half. We have 5 years, and then finally he's in this behavior mod program. Isn't that? I mean, that's at least on the face of his complaint. That's what he says, and you're not disputing that.
I would agree that is his complaint. I would not agree those are the correct facts.
Okay.
Because if the placement had been, or the recommendation had been for another type of behavior modification, there is a separate one for gang members. It's a different program, but it's also conducted within the confines of administrative segregation. Had he been placed in that one, then I think his complaint, well, I never should have been here because I'm not a gang member, would have been correct. I think he was, what he saw in his grievance, because he grieved it, 3.5 years later, saying I shouldn't have been here, it confirmed, no, that was not the reason that you were here. There was nothing in here. Why you're here is because you tried to solve this problem with violence.
But none of that's in the record before us today, is it? So what we're really focused on today is
No, yeah, I'm sorry. That's a problem. I've seen so many documents that what you have in your hands may be.
we have a very limited amount, and
Yeah.
that's why your counsel suggested that we have to accept his
I think-
allegations as true for purposes of the legal issue before us today.
Right, but if memory serves, he did include the unit team response that said, and I think it was from unit team member Marlette, said that it's not gang, and there was never gang. And that was
So in
really,
addition to serving the disciplinary seg at Lansing, he needed to continue an administrative seg at El Dorado because the disciplinary seg, the incident that led to the disciplinary seg involved violence and a weapon. That's your understanding?
that's the nut of it.
Okay.
And is he there for his own protection or the protection of his fellow inmates, or both?
I think it'd be, in this case, both. Whatever conflict had existed between these two offenders in Lansing, we can't have that continue. That's why we have things like called central monitoring. Once an offender has been involved in an act of aggression or violence towards another offender, we do what's called central monitoring. We split them up. We don't allow them to be in the same facility. We just, so to answer your question, it's both. And in this case,
I guess I misunderstood why we're here today. I thought we were going to talk about whether the duration of the administrative segregation would implicate a liberty interest such as would get the inmate into a hearing at which all of this could be brought up as to whether it's appropriate. I can foresee that the state could establish that 5 years was not a problem because, or was not a violation of due process because of a balancing situation, but we're not going to balance that today. I understood the issue was, can he even get into court with an allegation that I've been there too long? And why is duration, why doesn't it implicate due process? If someone's kept in segregation longer than is necessary for the purpose for which they were placed there, why isn't that a due process implication? That's what I understood the issue was today.
right, and my response to that is that even the cases that talk about duration also look at the conditions. That duration in and of itself doesn't tell you anything except the passage of time. There has to be more, so much more, to implicate a due process interest.
And do we have anything today that tells us about conditions? Do we have anything before us today that answers that question? If we accept your legal premise, that it takes more than duration, it also takes information about conditions, do we have any information in this record that tells us about conditions? Or do we have other information upon which we can rely because we can take judicial notice?
Based upon the record, probably not. What I would direct the court to are those two cases that I cited in my brief, both Stallings and Grissom, where challenges were made and an evaluation was done under what I call the DeMarco factors as to whether or not their conditions were severe at the El Dorado Correctional Facility in administrative segregation. Those two cases found that they are not. And I think it's for me one of those very challenging things, because everyone here, including members of the audience, has some sort of visual or image of what administrative segregation is, but it may not be like they think it is.
But does it have to be? I mean, isn't it enough that we know that administrative segregation, whatever it might be, is a more restrictive environment than the general prison population?
To know it in what respect? I mean, just to understand that
Requires you to go through a behavior because it might require you to go through a behavior modification program, which is something that other inmates in general population may not have to do. You may only see the light of day 1 hour. I mean, whatever it may be. Isn't it enough for us to know that administrative segregation is a different level of severity to being in prison in the general population?
I think it's certainly more restrictive in its movements.
And if that's enough, I mean, if we just accept that premise, then why doesn't an allegation that I've been here too long implicate the liberty interest under due process enough so that somebody can get into a hearing, a fact-based hearing, and find out what's going on? That's all we're talking about here, is whether you get to walk through the courtroom door to have some kind of additional fact-finding.
And I don't really have an answer for that question.
Because this guy got thrown out of court without the ability to have that fact-finding. And so whether that was appropriate or not is, I think, the only thing we can look at up here.
I understand that, and I think as I pointed out in the brief, I think every court has struggled with just that question. The 10th Circuit has developed what I've called the DeMarco test, or factors, they're not exclusive, but to give that district court some additional tools to say, okay, what is going on here? Should there be an absolute bar, to even a review? I think at least the 10th Circuit has taken the position, no, that's not correct. But we should have those factors clearly delineated so that we know what we're looking for.
Seems to me like you're agreeing with Mr. Jamerson's counsel that we at least have to have some parameters here, rather than just kicking Mr. Jamerson out of court summarily, which is what happened.
I don't disagree. I think it's a matter of what goes on and to what extent, we need to review those. And all I'm suggesting is that I understand this court's prior decision with Amos, and that has acted pretty much as a bar.
Well, Amos, correct me if my recitation, if you disagree with my recitation of Amos, but my understanding of Amos essentially is that this court held that administrative segregation does not place any atypical or significant hardships on an inmate. In other words, there are no conditions of administrative seg that by them, that the, in and of just knowing, as Justice Biles said, just knowing that somebody's in administrative segregation does not by itself create any atypical or significant hardship that would give rise to a liberty interest. That's Amos, right?
I believe so.
And so what we're here talking about today is whether or not the duration of an inmate's stay in administrative seg can create a liberty interest separate and apart from the conditions of that segregation. Is that a fair statement, or is that your understanding of what we're discussing here today?
I believe so, yes.
Okay, so I guess my follow-up question, I think you said, and I think there is case law that supports what you argued, that it has to be something more than just duration. And I guess my question then is, if an inmate simply filed a pro se motion and it was one sentence, and it said, I've been in administrative segregation for 50 years. I assume it's the state's position that that's not enough. Is that right?
That's correct.
Okay, and can you justify that position for me?
Well, and hopefully on a couple of levels. First of all, there would have to be administrative exhaustion that would occur that they would make that complaint internally.
Well, I'm just asking you to assume that we're here at this point, and that literally, it is that simple. It is just a one sentence allegation. I've been in administrative segregation for an extreme period of time. My suggestion was 50 years.
No, I don't think that would, because it doesn't tell you anything. It doesn't give the court any tools to look at and information to say, well, I mean, obviously the next question is why?
But you can't answer the why question unless the inmate is granted a due process hearing.
Or they have a more complete petition that perhaps outlines those.
Well, you're asking for a petition that would allege conditions that would give rise to a liberty interest.
Yes.
Okay.
So you're out of time. Do you have any further presentation?
Could I and this is maybe way off the record, but or out of the realm of typically what's asked, but in looking at administrative segregation, that some of my colleagues have asked, it's not just for the punitive aspect of that is typically dealt with disciplinary segregation and not administrative segregation. And administrative segregation is sometimes for institution management purposes, sometimes it's protection of the inmates, sometimes there's a lot of different reasons. It might even be based upon the crime that was committed. Why does that category, administrative segregation, appear to always equate to isolation? I mean, and maybe I'm wrong about that, but at least from what we've read from all of these briefs, it appears to be like and they might be exaggerating the conditions, but a 23-hour-a-day typical confinement, solitary confinement. You get an hour of isolated exercise to stretch, 3 showers a week, limited contact or no contact with other inmates, limited contact with prison personnel. It's pretty much isolated. Why does segregation appear to equate to isolation, or does it? Or why does it? Is that just for prison management purposes, or why is that?
That's a much more complicated question.
It probably is, and it's probably not. It's just an observation I have in just reading this. It just, why can't you just have a segregated building and have different levels there? And I don't understand why it appears that these complaints arise from these pretty extreme conditions.
I'll try and, to my best, explain as briefly as I can what segregation is at the El Dorado Correctional Facility. There are 2 buildings. It is 2 cell houses that they're single cells. You are limited in your movement, but you may be there for any number of reasons. Certainly, behavioral has the driver, but it could be protective custody.
Right.
It could be you're under a mental health watch under a crisis situation. It could be for, I hate to try and remember them all, but there are reasons. Yes, there are limited movement, but there's no real limitation on contact. I mean, you don't get a day room where you get to go out and mingle with other offenders. That doesn't happen. That's part of the reason that you're in segregation, because there has been some problem, or there's a potential for problem. That's what segregation is. The offenders in segregation, particularly administrative segregation, are permitted to have all of the privileges of a general population offender. They can sit there and watch TV all day if they choose to. They have telephones. They're not isolated. They're daily reviews, weekly reviews, monthly reviews. Yes, it's a limited contact, but it is not isolation, and never has been. I think that's one of the myths about.
Yeah, and that's what's not developed in the record.
Correct. I mean, and here I'm speaking far off, our topic, but it is, segregation is a necessary part of incarceration because there are unfortunately individuals who either cannot or choose not to control their behavior. We have certain degrees of segregation. We have what are called MRAs, which are more restricted access. Those offenders who have been violent towards a staff member, they're placed in another type of cell. So it's a very complicated question.
I appreciate that.
I would just wrap up and say that I don't think time tells you anything without a great deal more information. And I thank you.
Do we have any more questions? Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
Can you follow up on the last thing that counsel just said? Time doesn't tell you anything. Does time tell us anything? I mean, that's still, I think, that's the question here. Does time tell us anything or not?
Well, I think in Mr. Jamerson's case, which is the issue before the court, is the longer he was there, the more mental illnesses or phobias, so on, more problems like that he had. And his experience is not unusual. So I think it may not be conclusive that time would say this is absolutely wrong, but I think it's atypical enough that it should get him in the courthouse door for a hearing.
So time may not tell you if you're going to win or not.
Right.
But it may tell us enough to talk about it.
Right. That's what I'm trying to communicate.
Is there a specific duration that you're proposing creates a liberty interest, or is it just too long?
I think anything as short as the time spent in disciplinary administration, I wouldn't feel like I could stand up here and argue that is too long. But that's a matter of days.
Well, isn't that one of the problems with your argument, though, that it's an undefinable standard? In other words, duration can create a liberty interest, but I mean, short of just arbitrarily picking a number of days and saying over that you have a liberty interest and under that you don't, how do you know?
Well, I think that goes back to Justice Biles' question and conversation in that I think your question goes more towards, well, are you going to win?
No, it actually goes to whether or not you get to have the hearing. It is the same question as Justice Biles asks. I'm just asking it in the context of looking for an identifiable judicial standard that we can apply in all subsequent cases in a way that's essentially fair and even-handed. I just am looking for you to give me some guidance from your perspective as to how do we know? How do we know how long is too long?
I think it goes back to the individual and how the extended, however long, what that effect had on that individual.
So a period
That
of time
inmate.
for a period of time in segregation for one inmate might give rise to a liberty interest, whereas that exact same period of time in segregation for a different inmate may not give. I mean, that's the problem that I'm sort of zeroing in on, is that it's not an objective standard that we can apply to everyone.
Well, I think part of the problem for you and in arguing this case is the court, through its precedents, has said we aren't going to be the puppet masters of the correctional facilities. But there are still, when constitutional liberty interest comes in, then you have a responsibility to step up and set some parameters. And I don't know that you can say if it's 1 year, that's good, that's enough. But I still think that like Mr. Jamerson, if you've been there long enough that you've developed all these mental illnesses and conditions, that would,
What if Mr. Jamerson presents an unreasonable risk to the other inmates in the general population?
Well, I think, again, that goes back to whether he wins his hearing, but not whether he gets a hearing. Because I think,
Well, you would agree that the length of segregation that's permissible varies according to the individual inmate.
right.
And so I think what my colleague's trying to ask, why is that then a function of duration? Why does that state a claim when the duration is dependent upon the purpose for the segregation? Why can making the allegation of a certain duration state a claim, state a due process claim, when you've admitted that the duration really, or as your adversary said, time didn't tell us anything?
To be honest, I don't know how to answer your question. I think it's more complex, although, as far as succeeding, I think if an inmate can point out that I've been in, segregation for 5 years and have developed these problems, that's enough in a petition to get him in the courthouse. So, any other questions?
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.